This is a production of Cornell University.
Good afternoon. I'm Stuart Schwab, the Alan R. Tessler Dean of Cornell Law School. I'm delighted to welcome you to the Robert S. Stevens Lecture. We've actually got an overflow crowd coming up, and so as is typical in any occasion, no one sits in the very front row. We're going to invite some people who weren't allowed in to come and sit in the front row, so we'll just sort of proceed and welcome everyone who's coming in, and it's absolutely fine. And they aren't actually late comers, so we should treat them as part of a distinguished part of the crowd. In any event, it's a great honor to welcome you to the Stevens Lecture and to the Stevens Lecturer, Professor Martha Nussbaum, who will be introduced momentarily. The Stevens Lecture is one of the top intellectual events of the year here in the law school, and certainly this year is no exception. It was established in 1955 in honor of the former Cornell Law School Dean, Robert S. Stevens, who served as dean for 18 years from 1937 to 1954, momentous years, of course, the longest-serving dean in Cornell Law School's history. Real pleased by the turnout. The need for overflow is a nice problem to have that we're handling logistically. Thank you all for coming. I now turn the event over to Cynthia Bowman, the Dorothea S. Clark Professor of Law. Thank you, Cynthia.
Martha Nussbaum is the Ernest Freund Distinguished Service Professor of Law and Ethics at the University of Chicago. She holds appointments in Philosophy Department and the Law School and the Divinity School, as well as being an associate in the Classics Department and the Political Science Department and a member of the Committee on Southern Asian Studies and a board member of the Human Rights Program and founder and coordinator of the Center for Comparative Constitutionalism. Those involvements, along with her 33 honorary degrees and 20 books and numerous articles, tends to lead to lengthy introductions of her. I'll try to avoid that. This is, in fact, the second time I've introduced Martha Nussbaum at a major university lecture. The last time was the Rosenthal Lecture Series at Northwestern Law School. Those lectures appeared, as I recall, as part of her book, Love's Knowledge?
No, Poetic Justice.
Poetic Justice. Since that time, she's written a total of perhaps 16 more books. Now, this might not be quite so remarkable if they were all on ethics and classical philosophy, the field she studied at Harvard before teaching there. But Nussbaum's books range from classical philosophy and ethics to jurisprudence and legal analysis, literary criticism, theories of economic development, feminist theory, educational reform, and moral psychology. She is a genuine polymath. I've been wanting to use that word. And Nussbaum's writing demonstrates that she is immensely knowledgeable about each area she enters. She's passionate about and has made profound contributions to all of them. To her, we owe such insightful and useful concepts as capabilities analysis, the theory she developed with Amartya Sen in the 1990s, and has applied in several books since. Today, she takes off from another concept she has been developing in her writings, the politics of disgust, and applies that today in the context of same-sex marriage and constitutional law. Martha Nussbaum has become, to use that freighted term, one of our foremost public intellectuals. At breakfast today, my husband said to me, "Why don't you just say, everybody knows who Martha Nussbaum is. You're all here to hear her, not me, so I'm going to shut up and sit down." So that's just what I will do now. Martha?
Well, thank you, Dean Schwab, and especially Cynthia. And it's a great pleasure to be here giving the Stevens Lecture. And but not such a great pleasure to be doing it in a week where this issue has become much more. One has reasons for some alarm at what's happening with this issue. So this is part of a book that will come out in February on, in general, sexual orientation and constitutional law. So this is the part about marriage. But the theme running through the whole book is that we have been for a long time in the throes of a politics based on disgust and stigma, and now we're edging toward a politics based on equal respect and the recognition of equal humanity. But anyway, you'll see that theme come up later in this part. Marriage is both ubiquitous and central. All across our country, in every region, every social class, every race and ethnicity, every religion or non-religion, people get married. For many, if not most people, however, moreover, marriage is not a trivial matter. It's a key to the pursuit of happiness, something people aspire to and keep on aspiring to again and again, even if their experience has been far from happy. To be told you can't get married is thus to be excluded from one of the defining rituals of the American life cycle. The keys to the kingdom of the married might have been held only by private citizens, religious bodies and their leaders, families, other parts of civil society. So it has been in many societies throughout history. In the U.S., however, as in most modern nations, government currently holds those keys. Even if people have been married by their church or religious group, they are not married in the sense that really counts for social and political purposes unless they have been granted a marriage license by the state. Unlike private actors, however, the state really doesn't have complete freedom to decide who may and may not marry. The state's involvement raises fundamental questions about equality of political and civic standing. Same-sex marriage is currently one of the most divisive political issues in our nation. In November 2008, as you all know, Californians passed Proposition 8, a referendum that removed the right to marry from same-sex couples who had been granted that right by the courts. This result was rightly seen by the same-sex community as deeply degrading. The recent referendum in Maine is, if anything, more shocking, since it removes a right that was granted through the democratic legislative process. Analyzing this issue may help us understand what is happening in our country and where we may be able to go from here. Before we approach the issue of same-sex marriage, though, we ought to define marriage. But marriage, it soon becomes evident, is no single thing. It's plural in both content and meaning. The institution of marriage houses and supports several distinct parts of human life: sexual relations, friendship and companionship, love, conversation, procreation and child-rearing, mutual responsibility. Marriages can exist without each of these. We've always granted marriage licenses to sterile people, people too old to have children, irresponsible people, and people incapable of love and friendship. Impotence, lack of interest in sex, refusal to allow sexual intercourse may sometimes count as grounds of divorce, but they don't preclude marriage. Marriages can exist even in cases where none of those factors is present, though such marriages are probably unhappy. Each of these important aspects of human life, in turn, can exist outside of marriage, and they can even exist altogether outside of marriage, as is evident from the fact that many unmarried couples live lives of intimacy, friendship, and mutual responsibility, and have and raise children. Nonetheless, when people ask themselves what the content of marriage is, they typically think of this cluster of things. Nor is the meaning of marriage single. Marriage has first a civil rights aspect. Married people get a lot of government benefits that the unmarried usually don't get: favorable treatment in tax, inheritance, and insurance status, immigration rights, rights in adoption and child custody, decisional and visitation rights in health care and burial, the spousal privilege exemption when giving testimony in court, and yet others. Marriage has, second, an expressive aspect. When people get married, they typically make a statement of love and commitment in front of witnesses. Most people who get married view that statement as a very important part of their lives. Being able to make it, and to make it freely, not under duress, is taken to be definitive of adult human freedom. The statement made by the marrying couple is usually seen as involving an answering statement on the part of society. So we declare our love and commitment, and society, in response, recognizes and dignifies that commitment. And marriage has, finally, a religious aspect. For many people, a marriage is not complete unless it has been solemnized by the relevant authorities in their religion, according to the rules of that religion. Despite the fact that marriage has these three aspects, government currently plays a key role in all. It confers and administers benefits. It seems, at least, to operate as an agent of recognition or the granting of dignity. And it forms alliances with religious bodies. Clergy are always among those entitled to perform legally binding marriages. Religions may refuse to marry people who are eligible for state marriage, and they may also agree to marry people who are ineligible for state marriage. But much of the officially sanctioned marrying currently done in the U.S. is done on religious premises by religious personnel. What they are solemnizing when there is a license granted by the state is, however, not only a religious ritual, but also a public rite of passage, the entry into a privileged civic status. To get this privileged treatment under law, people do not have to show that they are good or even law-abiding people. Convicted felons, divorced parents who fail to pay their child support, people with a record of domestic violence or emotional abuse, delinquent taxpayers, drug abusers, rapists, murderers, racists, anti-Semites, other bigots, all can marry if they choose, and indeed have been held to have a fundamental constitutional right to do so. We'll come to that later, so long as they want to marry someone of the opposite sex. Although some religions urge premarital counseling and refuse to marry people who seem ill-prepared for marriage, the state does not turn such people away. The most casual whim may become a marriage with no impediment, but the time very short that it takes to get a license. Nor do people even have to lead a sexual lifestyle of the type the majority prefers in order to get married. Pedophiles, sadists, masochists, sodomites, transsexuals all can get married by the state so long as they marry someone of the opposite sex. Given all this, it seems odd to suggest that in marrying people, the state affirmatively expresses its approval or confers dignity. There is indeed something odd about the mixture of casualness and solemnity with which the state behaves as a marrying agent. Nonetheless, it seems to most people that the state, by giving a marriage license, expresses approval, and by withholding it, disapproval. Now, what is the same-sex marriage debate about? It's really not about whether same-sex relationships can involve the content of marriage. Few today would deny that gays and lesbians are capable of friendship, intimacy, what Milton called meet and happy conversation, and mutual responsibility, nor that they can and do have and raise children, whether their own from a previous marriage or children created within the relationship by surrogacy or artificial insemination or adopted children. Certainly, none would deny that gays and lesbians are capable of sexual intimacy. Nor is the debate currently about the civil aspects of marriage. We're at least moving toward a consensus that same-sex and opposite-sex couples ought to enjoy equal civil rights. The leaders of both major political parties appeared to endorse this position during the 2008 presidential campaign, although only a handful of states have, in fact, legalized civil unions with material privileges equivalent to those of marriage. And finally, the debate is not about the religious aspect of marriage. Most of the major religions have their own internal debates, usually heated, over the status of same-sex unions. Some denominations, Unitarian Universalism and both Reform and Conservative Judaism, have endorsed marriage for same-sex couples. Others have taken a friendly position toward these unions. Presbyterians, Lutherans, and Methodists are divided on the issue at present, And American Roman Catholics, both lay and clergy, are also divided, although the church hierarchy is strongly opposed. Still other religions, Southern Baptists, the Church of Jesus Christ of Latter-day Saints, seem strongly opposed as a body to the recognition of such unions. So there's no single religious position on same-sex unions in America today, but the heat of these debates is typically internal and denominational. It's not that heat that spills over into the public realm. Under any state of the law, moreover, religions would be free to marry or not marry same-sex couples, just as they are now free to marry or not marry divorced people, interfaith couples, and so on. And I think that's important to stress. My own daughter, who married somebody who wasn't a Jew, her rabbi refused to marry her, and she had to look around for somebody who would marry her, and that's a typical situation. There's no obligation to marry, even though they're perfectly eligible for marriage. The public debate, instead, is primarily about marriage's expressive aspects. It's here that the difference between civil unions and marriage resides, and it's this aspect that's at issue when same-sex couples see the compromise offer of civil unions as stigmatizing and degrading. Now, this expressive dimension of marriage raises several distinct questions. First, assuming that granting a marriage license does express a type of public approval, should the state actually be in the business of expressing favor for or dignifying some unions rather than others? In other words, are there any good public reasons for the state to be in the marriage business at all, rather than the civil union business? And second, if there are such good reasons, what are the arguments for and against admitting same-sex couples to that status? And how should we think about them? So before I address those questions, though, a little historical excursion. Marriage in history, the myth of the Golden Age. When people talk about the institution of marriage these days, they often wax nostalgic. Until very recently, they think and often say, marriage used to be a lifelong commitment by one man to one woman, sanctified by God and the state for the purposes of companionship and the rearing of children. People lived by those rules and were happy. Typical, if somewhat rhetorical, is this statement by Senator Robert Byrd of West Virginia during the debates over the Defense of Marriage Act. Mr. President, throughout the annals of human experience, in dozens of civilizations and cultures of varying value systems, humanity has discovered that the permanent relationship between men and women is a keystone to the stability, strength, and health of human society, a relationship worthy of legal recognition and judicial protection, end quote. So the story goes, we used to live in that golden age of marital purity. Now, however, things are falling apart. Divorce is ubiquitous. Children are growing up without sufficient guidance, support, and love as adults live for pleasure alone. So we need to come to our senses and return to the rules that used to make us all happy. Like most Golden Age myths, this one contains a core of truth. Commitment and responsibility are under strain in our culture, and too many children are indeed growing up without enough economic or emotional support. But we can't think well about how to solve that problem unless we first recognize the flaws in this mythic depiction of our own past. Like all fantasies of purity, this one masks a reality that's far more varied and complex. To begin with, Senator Byrd's idea that lifelong monogamous marriage has been the norm throughout human history is just plain mistaken. Many societies have embraced various forms of polygamy, informal or common law marriage, and sequential monogamy. People who based their ethical norms on the Bible too rarely take note of the fact that the society depicted in the Old Testament is polygamous. In many other ancient societies, and some modern ones, sex outside marriage was or is a routine matter. As in ancient Greece, for example, married men routinely had socially approved sexual relationships with prostitutes, male and female, and with numerous restrictions with younger male citizens. One reason for this custom was that women were secluded and undereducated, thus not able to share a male's political and intellectual aspirations. If we turn to Republican Rome, a society more like our own in basing marriage on an idea of love and companionship, we find that this very ideal gave rise to widespread divorce, as both women and men sought a partner with whom they could be happy and share a common life. We hardly find a major Roman figure, male or female, who did not marry at least twice. These Romans are often admired, and rightly so, I think, as good citizens, people who believed in civic virtue and tried hard to run a government based on that commitment. Certainly for the founders of the U.S., the Roman Republic was a key source of both political norms and personal heroes. And yet, these heroes did not live in a marital Eden. In fact, there's no better antidote, I think, to the myth of marital purity than to read Cicero's account of the unhappy marriage of his brother Quintus to Pomponia Attica, the sister of his best friend Atticus. Through his narrative, however biased in his brother's favor, we get a glimpse of something so familiar that it's difficult to believe that it all happened around 50 BC. Cicero's out in the country on one of his estates, and his brother has, it seems, dragged his unwilling wife away from the city and her friends to spend a week on the farm with a brother-in-law who doesn't like her and who, despite his undoubted greatness, is more than a little self-obsessed. So here's how Cicero tells the story. When we arrived there, Quintus said in the kindest way, "Pomponia, will you ask the women in?" Both what he said and his intention and manner were perfectly pleasant. At least it seemed so to me. Pomponia, however, answered in our hearing, "I am a guest here myself." Quintus said to me, "This is the sort of thing I have to put up with every day." I myself was quite shocked. Her words and manner were so gratuitously rude. And then they all go into lunch, except for Pomponia, who goes straight to her room and says she wants her lunch to be brought up to the room. And then she refuses the food when it is brought up. In a word, I felt my brother could not have been more forbearing, nor your sister ruder. And I have left out a number of things that annoyed me at the time more than they did Quintus. Well, then, the following day, Quintus comes out and has a talk with his brother, and he told me that Pomponia had refused to sleep with him and that her attitude when he left the house was just as I had seen it the day before. Well, you can tell her for me that her whole conduct was lacking in sympathy. Well, the marriage lasted 6 more unhappy years and then ended in divorce. The shock of seeing our own face in the mirror of Cicero's intimate narrative reminds us that human beings always have a hard time sustaining love and even friendship, that bad temper, incompatibility, and divergent desires are no invention of the sexual revolution. Certainly, they are not caused by the recognition of same-sex marriage. We have always lived in a post-lapsarian world. The rise of divorce in the modern era, moreover, was spurred not by a hatred of marriage, but rather more by a high conception of what marriage ought to be. It's not just that people began to think that women had a right to divorce on grounds of bodily cruelty, and that divorce of that sort was a good thing. It's also that Christians began insisting, just like those ancient Romans, that marriage was about much more than procreation and sexual relations. John Milton's famous defense of divorce on grounds of mutual incompatibility emphasizes what he called meet and happy conversation as the central goal of marriage, and notes that marriage ought to fulfill not simply bodily desires, but also what he calls the intellectual and innocent desire that leads people to just want to talk a lot to each other. People are entitled to demand that from their marriages, he argues, and entitled to divorce if they don't find it. If we adopt Milton's attractive view, we should not see divorce as necessarily expressing a falling away from high moral ideals, but rather as expressing often an unwillingness to put up with a relationship that does not fulfill or at least seriously pursue high ideals. In our own nation, as historians of American marriage emphasize, a social norm of monogamous marriage was salient from colonial times onward. The norm, however, like most norms in all times and places, was not the same as the reality. Studying the reality of marital discord and separation in America is very difficult because many, if not most, broken marriages were not formally terminated by divorce, given that divorce until rather recently was hard to obtain, and given that America offered so much space for relocation and the reinvention of self, many individuals, both male and female, simply moved away and started life somewhere else. A man who showed up with a wife in tow was not likely to encounter a background check to find out whether he had ever been legally divorced from a former spouse. Such background checks across state lines would have been virtually impossible. A woman who showed up calling herself the Widow Jones would not be asked to show her husband's death certificate before she could form a new relationship and marry. The cases of separation that do end up in court are the tip of a vast, uncharted iceberg. If, as historian Hendrik Hartog concludes about the 19th century, marital mobility marked American legal and constitutional life, it marked far more the daily lives of Americans who did not litigate their separations. Insofar as monogamy was reality, we should never forget that it rested on the disenfranchisement of women. Indeed, the rise of divorce in recent years is probably connected to women's social and political empowerment more than to any other single factor. When women had no rights, no marketable skills, and hence no exit options from a bad marriage, they often had to put up with adultery, neglect, and even domestic violence. When women are able to leave, they demand a better deal. This simple economic explanation for the rise of divorce, combined with Milton's emphasis on people's need for emotional attunement and conversation, is much more powerful than the idea of a lapse from ethical purity in explaining how we've moved from where we were to where we are today. But if such factors are salient, denial of marriage to same-sex couples is hardly the way to address them. Throughout the 19th and early 20th centuries, moreover, a distinctive feature of American marriage has been the strategic use of federalism. Marriage laws have always been state laws, despite recurrent attempts to legislate a national law of marriage and divorce. But states in the U.S. have typically used that power to compete with one another, and marriage quickly became a scene of competition. Long before Nevada became famous as a divorce haven with its short residency requirement, other states assumed that role. For quite a stretch of time, surprisingly, I think, Indiana was the divorce haven for couples fleeing the strict requirements of states such as New York, which was one of the strictest until very recently, and the neighboring Wisconsin. The reasons why a state liberalized its laws were complex, but at least some of them were economic. While couples lived out the residency requirement, they would spend money in the state. In short, marriage laws, as Hartog says, quote, became public packages of goods and services that competed against the public goods of other jurisdictions for the loyalty and the tax dollars of a mobile citizenry. What we're seeing today with same-sex marriage, I think, is that same sort of competitive process with, however, one salient difference. The Federal Defense of Marriage Act has made it clear that states need not give legal recognition to marriages legally contracted elsewhere. That was not the case with competing divorce regimes. Once legally divorced in Indiana, the parties were considered divorced in Wisconsin. Although the situation of non-recognition faced by same-sex couples does not parallel the history of varying divorce regimes, it does have one major historical precedent. States that had laws against miscegenation refused to recognize marriages between blacks and whites legally contracted elsewhere, and even at times criminalized those marriages. The Supreme Court case that brought about the overturning of the anti-miscegenation laws, Loving versus Virginia, 1967, was such a case. Mildred Jeter, an African American, and Richard Loving, who was white, got married in Washington, D.C. in 1958. Their marriage was not recognized as legal in their home state of Virginia. When they returned to that state, they were arrested in the middle of the night in their own bedroom with a copy of the marriage license framed above their bed. The state prosecuted them, since interracial marriage was a felony in Virginia, and they were convicted. The judge then told them either to leave the state for 25 years or to spend 1 year in jail. They left, but then they began the litigation that led to the landmark decision. In 2007, on the 50th anniversary of that decision, Mildred Jeter, who died last year, issued a rare public statement saying that she saw the struggle she and Richard waged as similar to the struggle of same-sex couples today. She wrote, "My generation was bitterly divided over something that should have been so clear and right, The majority believed that it was God's plan to keep people apart and the government should discriminate against people in love. But the older generation's fears and prejudices have given way, and today's young people realize that if someone loves someone, they have a right to marry. Surrounded as I am now by wonderful children and grandchildren, not a day goes by that I don't think of Richard and our love, our right to marry, and how much it meant to me to have that freedom to marry the person precious to me, even if others thought he was the wrong kind of person for me to marry. I believe all Americans, no matter their race, no matter their sex, no matter their sexual orientation, should have the same freedom to marry. Well, she makes a powerful argument, but let's first consider the arguments on the other side. As we examine the arguments against same-sex marriage, we should keep two questions firmly in mind. First, does each of these arguments really justify legal restriction of same-sex marriage or only some people's attitudes of moral or religious disapproval? We live in a country where people have a wide range of different religious and secular beliefs, and we agree in respecting the space within which people pursue those beliefs. We do not, however, agree that these beliefs by themselves are sufficient grounds for legal regulation. Typically, we understand that some arguments, including some, though not all, religious arguments, are public arguments bearing on the lives of citizens in a decent society, and others are simply intra-religious arguments. Thus, observant Jews abhor the eating of pork, but few, if any, would suppose that this religiously grounded prohibition is a reason to make the eating of pork illegal for everyone. The prohibition rests on religious texts and arguments that not all citizens embrace, and it can't be translated into a public argument that people of all religions can accept without conversion. Similarly, in this case, we should ask whether the arguments against same-sex marriage are expressed in a neutral and shareable language or only in a sectarian doctrinal language. If the arguments are moral rather than textual, they may fare better, but we still have to ask whether they're compatible with core values of a society dedicated to giving all citizens the equal protection of the laws. Many legal aspects of our history of racial and gender-based discrimination were defended by secular moral arguments, but that didn't insulate them from constitutional scrutiny. Second, we ought to ask whether each argument really justifies its specific conclusion or whether there's reason to see the argument as a rationalization of some deeper sort of anxiety or aversion, animus, to use the legal language of Romer versus Evans. All right, so the first and most widespread argument against same-sex marriage is that it's immoral and unnatural. Similar arguments were widespread in the anti-miscegenation debate. And in both cases, these arguments are typically made in a sectarian and doctrinal way, referring to religious texts. Anti-miscegenation judges, for example, referred to the will of God in arguing that racial mixing is unnatural. It's difficult to cast such arguments in a form that could be accepted by citizens whose religion or secular view teaches something different. They really look like Jewish arguments against the eating of pork, good reasons for members of some religions not to engage in same-sex marriage, but not sufficient reasons for making them illegal for all in a pluralistic society. A second objection, and perhaps the one that's most often heard from thoughtful people, insists that the main purpose of state-sanctified marriage is procreation and the rearing of children. Protecting an institution that serves these purposes is a legitimate public interest, and so there's a legitimate public interest in supporting potentially procreative marriages. Does this really entail the conclusion that there's also a public interest in restricting marriages to those cases where there may be procreation? This is far less clear. I think we can agree that procreation, protection, and the safe rearing of children are important public purposes. It's not clear, however, that we've ever thought these important purposes best served by restricting marriage to the potentially procreative. If we ever did think like this, we certainly haven't done anything about it. We have never limited marriage to the fertile or even those of an age which might be fertile. it's very difficult in terms of the state's interest in procreation to explain why the marriage of two heterosexual 70-year-olds should be permitted and the marriage of two men or two women should be forbidden, all the more since so many same-sex couples have, adopt, or in other ways raise children. As it stands, then, the procreation argument looks two-faced, approving in heterosexuals what it refuses to tolerate in same-sex couples. If the arguer should add that sterile heterosexual marriages somehow support the efforts of the procreative, we could reply that gay and lesbian couples who don't have and raise children may also support, similarly, the work of procreative couples. Sometimes this argument is put a little differently. Marriage is about the protection of children. And we know that children do best in a home with one father and one mother, so there's a legitimate public interest in supporting an institution that fulfills this purpose. Put this way, the argument again offers, at least on its face, a legitimate public reason to favor and support heterosexual marriage, though it's less clear why it gives a reason to restrict same-sex marriage and marriages of those too old to have children or not desiring children, etc. Its main problem, however, is with the facts. Again and again, psychological studies have shown that children do best when they have love and support. And that's not so surprising. And it appears that two-parent households often do better at that job than single-parent households. There's no evidence, however, that opposite-sex couples do better than same-sex couples. There's a widespread feeling that the results of these psychological studies can't be right, that living in an immoral atmosphere must be bad for the child, but that feeling rests on the religious judgments of the first argument, when the well-being of children is defined in a religiously neutral way. There really is no difference. A third argument is that by conferring state approval on something that many people believe to be evil, same-sex marriage will force those people to bless or approve of it, thus violating their conscience. This argument was recently made in an influential way by Charles Freed, professor at Harvard Law School and former Solicitor General of the United States, in his book Modern Liberty. Freed, who supports an end to sodomy laws and expresses considerable sympathy with same-sex couples, still thinks that marriage goes too far because of this idea of enforced approval. So what precisely is the argument that Freed's making? Freed does not suggest that the recognition of same-sex marriage would violate the free exercise clause of the First Amendment, and I think wisely, because I think that would be a very implausible position to take. Presumably, then, the position is that the state has a legitimate interest in banning same-sex marriage on the grounds that it offends deeply many religious believers. Now, put that way, the argument, I think, contains some difficulties. First, it raises an Establishment Clause problem. For, as we've seen, religions vary greatly in their attitude to same-sex marriage. And the state, following this argument, would be siding with one group of religious believers against another. More generally, there are a lot of things that a modern state does that people deeply dislike, often on religious grounds. Public education teaches things that many religious parents don't like, such as evolution and the equality of women. Parents often choose homeschooling for that reason. Public health regulations license butchers who cut up pigs for human consumption. Jews don't want to be associated with that practice. But nobody believes that Jews have a right to ask the state to impose their religiously grounded preference on all citizens. The old order Amish didn't want their children to attend public school past age 14, holding that such schooling is destructive of the Amish community. The state respected that choice for Amish children, and the state even allows Amish children to be exempt from some generally applicable laws for reasons of religion. But nobody would dream of thinking that the Amish have a right to expect the state to make public schooling past age 14 off limits for all American children. Part of life in a pluralistic society that values the non-establishment of religion is an attitude of live and let live. Whenever we see a nation that does allow the imposition of religiously grounded preferences on all citizens, as with some Israeli laws imposing bans on various activities on the Sabbath, and as with laws in India banning cow slaughter, we see a nation with a religious establishment, de jure or de facto. We've chosen not to take that route, and for good reasons. To the extent that we choose work days, holidays, and so on that do coincide with the preferences of a religious majority, we bend over backwards to be sensitive to the difficulties this imposes on minorities. A fourth argument, again appealing to a legitimate public goal, focuses on the difficulties that traditional marriage appears to be facing in our society, pointing to rising divorce rates and evidence that children are being damaged by lack of parental support. People say we need to defend traditional marriage, not to undermine it, by opening the institution to those who don't have concern for its traditional purposes. Now, of course, we should begin by contesting this description of same-sex couples. In large numbers, they do have and raise children. Marriage for them, as for other parents, provides a clear framework of entitlements and responsibilities, as well as security, legitimacy, and social standing for their children. In fact, the states that have legalized same-sex marriage have among the lowest divorce rates in the nation, Massachusetts and Connecticut, at least. It's too soon to tell with Iowa. And the Massachusetts evidence shows that the rate has not risen as a result of the legalization. We might also pause before granting that an increase in the divorce rate signals social degeneration. Often, as I've said, women stayed married, enduring neglect and even abuse because they had no exit options. But okay, let's concede for the sake of the argument that there is a social problem. What about the claim that legalizing same-sex marriage would undermine the efforts to defend or protect traditional marriage? If society really wants to protect traditional marriage, as it certainly is entitled to do, many policies suggest themselves. Family and medical leave, drug and alcohol counseling on demand, generous support in health policies for marital counseling and mental health treatment, strengthening laws against domestic violence and enforcing them better, employment counseling and financial support for parents under stress during the present economic crisis, and, of course, tighter enforcement of child support laws. Such measures have a clear relationship to the stresses and strains that traditional marriage is facing. The prohibition of same-sex marriage does not. If we were to study heterosexual divorce, we would be unlikely to find even a single case in which the parties truly felt that their divorce was caused by the availability of marriage to same-sex couples. Divorce is usually an intimate personal matter bearing on the nature of an individual relationship. The objector at this point typically makes a further move. The very recognition of same-sex marriage on a par with traditional marriage demeans traditional marriage, makes it less valuable. Now, all right, what's being said here, I think, is something like this. If the Metropolitan Opera auditions started giving prizes to pop singers of the type who perform on American Idol, this would certainly demean the honor and contaminate the opera world. Similarly, including in the Hall of Fame baseball players who are known to have used steroids cheapens the real achievement of the others who didn't do that. In general, so the point seems to be the promiscuous recognition of low-level or non-serious contenders for an honor sullies that honor. I think that's the sort of argument that people are making when they assert that recognition of same-sex marriage defiles traditional marriage, when they talk about a defense of marriage and so on. Well, all right, how should we evaluate that argument? First of all, we should challenge it on the facts. Same-sex couples are not like B-grade singers or cheating athletes, or at least no more so than heterosexual couples. They want to get married for reasons very similar to those of heterosexuals, to express love and commitment, to gain religious sanctification for their union, to obtain a package of civil benefits, and often to have or raise children. Traditional marriage has its share of creeps, and there are same-sex creeps as well. But the existence of creeps among the heterosexuals has never stopped the state from marrying heterosexuals. Nor do people talk or think that way. I've never heard anyone say that the state's willingness to marry Britney Spears or O.J. Simpson demeans or sullies their own marriage. But somehow, without even knowing anything about the character or intentions of the same-sex couple next door, they do think that their own marriages would be sullied by the public recognition of that union. If the the proposal were to restrict marriage to worthy people who have passed some sort of character test, it would at least be consistent, though I think few of us would support such an intrusive regime. What's clear is that those who make the argument do not fret about the way in which unworthy or non-serious heterosexuals might sully the institution of marriage or lower its value. Given that they don't fret about this, and given that they don't want to allow marriage for gays and lesbians who have proven their good character, it's difficult to take this argument at face value. The idea that same-sex unions will defile traditional marriage, therefore, cannot be understood ultimately without moving to the terrain of disgust and contamination. The only distinction between unworthy heterosexuals and the class of gays and lesbians that can possibly explain the difference in people's reaction is that the sex acts of the former do not disgust the majority when they think about them, whereas the sex acts of the latter often do. The thought must be that to associate traditional marriage with the sex acts of same-sex couples is to defile or contaminate it in much the way that eating food served by a dalit used to be taken by many people in India to contaminate the high caste body, or the way in which, of course, in the American South, using a drinking glass or water fountain, swimming pool that an African American person had used would be taken to be using a contaminated object. Nothing short of a primitive idea of stigma and taint can explain the widespread feeling that same-sex marriage defiles or contaminates straight marriage, while the marriages of immoral and non-serious heterosexuals do not. If the arguer should reply that marriage between two people of the same sex can't result in procreation and so must be a kind of pretend or sham marriage, which parodies and thus demeans the real sort of marriage, we're right back to the second argument, the procreation argument. Those who insist so strongly on procreation do not feel sullied or tainted by the presence next door of two opposite-sex 70-year-olds who've just decided to get married, nor by the presence of opposite-sex couples who publicly announce their intention not to have children. They do not try to get lawmakers to make such marriages illegal, and they neither say nor feel that such marriages are immoral or undermine their own. So the feeling of undermining and demeaning can't honestly be explained by the point about procreation and has to be explained instead by other darker ideas. If we're looking for a historical parallel to the anxieties associated with same-sex marriage, we can find it in the history of views about miscegenation. At the time of Loving versus Virginia in 1967, 16 states both prohibited and punished marriages across racial lines. In Virginia, as we've seen, such marriage was a felony, and it was punishable by from 1 to 5 years in prison. Like same-sex marriages, cross-racial unions were opposed with a variety of arguments, both political and theological. In hindsight, however, we can clearly see that disgust and stigma were at work. Indeed, disgust did not hide its hand. The idea of racial purity was proudly proclaimed, for example, in the Racial Integrity Act of 1924 in Virginia. And ideas of contamination and taint were ubiquitous. If people really felt disgusted and contaminated by the thought that a black person had drunk from the same public drinking fountain, or gone swimming in the same pool, or used the same toilet, all views, by the way, on which I personally was brought up by a father from the Deep South, so I know very well how, a practicing lawyer, a partner in a Philadelphia firm, really had these ideas that if the African-American person had used a certain glass, you could never use that glass again, ever. So it's amazing how people can believe this, but they do. The Supreme Court concluded that such ideas of racial stigma were the only ideas that really supported those laws, whatever else was said. Quote, "There is patently no legitimate overriding purpose independent of invidious racial discrimination which justifies this classification," end quote. And I think we should draw the same conclusion about the prohibition of same-sex marriage. Irrational ideas of stigma and contamination, the sort of animus the court recognized in Romer, is a powerful force in its support. So thought the Supreme Court of Connecticut in October 2008, saying, quote, Beyond moral disapprobation, gay persons face virulent homophobia that rests on nothing more than feelings of revulsion toward gay persons and the intimate sexual conduct with which they are associated. Such visceral prejudice is reflected in the large number of hate crimes that are perpetrated against gay persons. The irrational nature of the prejudice directed at gay persons who are ridiculed, ostracized, despised, demonized, and condemned merely for being who they are is entirely different in kind from the prejudice suffered by other groups that previously have been denied a suspect or quasi-suspect class status, and so on. So we've now gone through the main arguments against same-sex marriage. They don't seem particularly impressive. We certainly don't seem to have seen any that would supply government with a compelling state interest. And it seems likely, given Romer, that these arguments motivated by animus fail even the rational basis test. But now we should look into the constitutional tradition. Okay. In our constitutional tradition, there's frequent talk of a right to marry. In Loving, the court calls marriage one of the basic civil rights of man. A later case, Zablocki versus Redhale, recognizes the right to marry as a fundamental right for 14th Amendment purposes, apparently under the Equal Protection Clause. The court states, quote, "The right to marry is of fundamental importance for all individuals," note, and continues with the observation that, quote, "The decision to marry has been placed on the same level of importance as decisions relating to procreation, childbirth, child rearing, and family relationships." Well, before courts can sort this issue out further with respect to same-sex marriage, they have to figure out two things. What is this right to marriage and who has it? What does the right to marriage mean? On a minimal understanding, it just means that if the state chooses to offer a particular package of expressive and or civil benefits under the name marriage, it must make that package available to all who seek that status without discrimination. Though here, all will require further argument, and we'll get to that. Loving concerned the exclusion of interracial couples from the institution. Zablocki similarly concerned the attempt of the state of Wisconsin to deny marriage to parents who could not show that they'd met their child support obligations. Another pertinent case, Skinner versus Oklahoma, invalidated a law mandating the compulsory sterilization of the so-called habitual criminal, saying that such a person, and again, once again, note that it's an individual right, it's understood as an individual right, being cut off from marriage and procreation would be, quote, "forever deprived of a basic liberty." A more recent case, Turner versus Safley, invalidated a prohibition on marriages by prison inmates. And note that these were inmates serving life terms, and the court recognized that they might never even physically meet their spouse, and it would only be in a rare case that that marriage would be consummated. But it was they still had a fundamental right to marry. All the major cases then turn on the denial to a particular group of people of an institutional package already available to others. Is the right to marry then merely a non-discrimination right? If so, the state is not required to offer marriage at all. It's only that once it does so, it must do so with an even hand. The talk of marriage as a fundamental right, together with the fact that most of these decisions mingle equal protection analysis with due process considerations, suggests, however, that something more is being said. What is it? Would it violate the Constitution if the state decided it would offer only civil unions and drop the status of marriage, leaving that to religious and private bodies? Put in terms of our three categories, then, does the right to marry obligate a state to offer a set of economic and civil benefits to married people? Does it obligate a state to confer dignity and status on certain unions by the use of the term marriage? And does it require the state to recognize or validate some unions approved by religious bodies? Well, clearly the answer to the third question is and always has been no. Many marriages that are approved by religious bodies are not approved by the state, of course. It's also pretty clear that the right to marry does not obligate the state to offer any particular package of civil benefits to people who marry. This has repeatedly been said by the court in cases dealing with the marriage right. On the other side, it looks like the right in question is not simply a right to be treated like others without group-based discrimination. The right to marry is frequently classified with fundamental personal liberties protected by the Due Process Clause of the 14th Amendment. In Meyer versus Nebraska, for example, the court says that the liberty protected by that Due Process Clause, quote, without doubt, denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized as essential to the orderly pursuit of happiness by free men. Loving, similarly, states that the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state, grounding this conclusion in the Due Process Clause as well as the Equal Protection Clause. Zablocki allows that, quote, reasonable regulations that do not significantly interfere with decisions to enter into the marital relationship may legitimately be imposed, end quote. But concludes that the Wisconsin law, remember that's the one that if you haven't met your child support payments, you can't get married, goes too far, violating rights guaranteed by the Due Process Clause. Turner versus Safley, similarly, determines that the restriction of prisoner marriages violates the Due Process Clause's privacy right. So what does due process liberty mean in this case? Most of the cases concern attempts to forbid a class of marriages, and that kind of interference with marriage is apparently unconstitutional on due process as well as equal protection grounds. So it looks like if the state just forbade everybody to marry, that would be presumptively unconstitutional. Nowhere, however, has the court ever held that the state must offer the expressive or dignitary benefits of marriage. There would appear to be no constitutional barrier to the decision of a state to get out of the expressive game altogether, going over to a regime of civil unions or private contract, except that it's clear from the precedents that they can't do that in order to refuse to marry same-sex couples. The states that decided to just close all the public swimming pools in order not to integrate them were held not to have the right to do that. So that group of race cases shows us that they can't withdraw it if the purpose is simply to refuse to marry same-sex couples. So again, the issue turns on equality. What the cases consistently hold is that when the state does offer a status that has both civil benefits and expressive dignity, it must offer it with an even hand. Now, that position, which I've called minimal, is not so minimal once one looks into it. Laws against miscegenation were, of course, very heavily defended. So in other words, it looks like marriage is a fundamental liberty right of individuals, which cannot be just removed wholesale by the state. And because it's that, it also involves an equality dimension. Groups of people can't be fenced out of that fundamental right without some overwhelming state reason. So it's like the voting right, which of course is not mentioned in the Constitution either. There isn't a constitutional right to vote as such. That is to say, some jobs can be filled by appointment, but the minute voting is offered, it's unconstitutional to fence out a group of people from the exercise of that right. At this point, then, the question becomes, well, who has that liberty, equality, right to marry, and what reasons are strong enough to override it? So who has the right? At one extreme, it seems clear that under current law, the state that offers marriage is not required to offer it to polygamous unions. Whatever one thinks about the moral issues involved in polygamy, our constitutional tradition has upheld a law making polygamy criminal, so it's clear at present that polygamous unions do not have equal recognition. The legal arguments against polygamy are, I think, quite weak. The primary state interest that's strong enough to justify legal restriction is an interest in the equality of the sexes, which was not mentioned in that case, and which would not tell against a regime of sex-equal polygamy. Regulations on incestuous unions have also typically been thought to be reasonable exercises of state power, although here again, the state interests have been defined very vaguely. The interest in preventing child abuse would seem to justify a ban on most cases of parent-child incest, but it's unclear that there's any strong state interest that should block adult brothers and sisters from marrying. the health risk involved is no greater anyway than in many cases where the couple is permitted to marry. Nonetheless, it's clear that if a brother-sister couple challenged such a restriction today on due process equal protection grounds, they would lose because the state's alleged health interest in forbidding such unions would prevail. Now, how should we analyze those cases? Should we think that these individuals have a right to marry as they choose, but that the state has a countervailing interest that in this case prevails? Or should we think that they don't have the right at all, given the nature of their choices? I think the former view is clearly the right one, given the history. That is, that all individuals have that right, that it can be defeated only by a sufficiently strong state interest. At the other extreme, it's also very clear that the liberty and equality rights associated with the right to marry do not belong only to the potentially procreative. The prisoner case concerned, as I say, marriage between people, most of whom would never meet their spouses. The case rested on the emotional support provided by marriage and its religious and spiritual significance to the individual. At one point, the court does mention as an additional factor the fact that a few of these inmates might actually someday be released and then they'd be able to consummate their union. But that was clearly not the basis for the holding. Nor does any other case suggest that the elderly or the sterile or even deathbed marriages would be in difficulty. So the best way of summarizing the tradition seems to be this. All adults have a right to choose whom to marry. They have this right because of the emotional and personal significance of marriage, as well as its procreative potential. This right is fundamental for due process purposes, and it also has an equality dimension. No group of people may be fenced out of this right without an exceedingly strong state justification. Now, let's look at how this has been actually put to work in the recent state cases. Okay, so recent state court decisions had to answer 4 questions using, of course, not just federal constitutional law, but also the text and tradition of their state constitutions. First, will civil unions suffice, or is the status of marriage constitutionally compelled? Second, is the issue one of due process or equal protection, or a mixture of the two? Third, in assessing the putative right against the countervailing claim of state interest, is sexual orientation a suspect classification for equal protection purposes? In other words, does the state forbidding such unions have to show a mere rational basis for the classification, or rather a compelling state interest? And fourth, what interests might so qualify? Okay, so the 4 states whose Supreme Courts have recently held that there is a constitutional right to marry that covers same-sex couples, Massachusetts, California, Connecticut, and Iowa, give different answers to these questions, but there's a large terrain of agreement. All agree that as currently practiced, marriage is a status with a strong component of public dignity. Because of that unique status, it's fundamental to individual self-definition, autonomy, and the pursuit of happiness. So the right to marry does not belong only to the potentially procreative. The Massachusetts court stresses that people who cannot stir from their deathbed are still allowed to marry. For all these expressive reasons, it seems to all these courts that civil unions are a kind of second-class status, lacking the affirmation and recognition characteristic of marriage. As the California court put it, the right is not the right to a particular word, it's the right, quote, to have their family relationship accorded the dignity and respect equal to that accorded other officially recognized families. 3 of the decisions draw on the miscegenation cases to make this point. The California court notes that if the states opposed to miscegenation had decided to create a new category called transracial union and extended that to transracial couples, that clearly would not have been a solution to the constitutional problem. 3 of the 4 courts invoke both due process and equal protection. Iowa does mention liberty briefly, but it grounds the analysis on equality alone. The Massachusetts court notes that the 2 guarantees frequently overlap, as they do here. They all agree that the right to marry is an individual liberty. So in other words, not a right of certain kinds of couples. It's an individual liberty right that also involves an equality component. A group of people can't be fenced out of that right without a very strong governmental justification. How strong? Well, here the states diverge. The Massachusetts court held that the denial of same-sex marriages fails to pass even the rational basis test. California, Connecticut, and Iowa, by contrast, hold that sexual orientation is a suspect classification analogizing sexual orientation to gender. What state interests lie on the other side? Well, all the ones that I've gone through are gone through in these cases, and California, Connecticut, and Iowa particularly carefully examine all the main contenders, and they conclude that none rises to the level of a compelling state interest. These opinions will not convince everyone, nor will all who like their conclusion or even their reasoning agree that it's good for courts to handle this issue rather than democratic majorities. But the opinions, I believe, should convince a reasonable person that constitutional law, and therefore courts, have a legitimate role to play in this divisive area, standing up for minorities who are at risk in the majoritarian political process. So to conclude the future of marriage, what ought we to hope and work for as a just future for families in our society? Should government continue to perform marriages at all? Should it drop the expressive dimension and simply offer civil union packages? Should it back away from package deals entirely in favor of a regime of disaggregated benefits and private contract? Such questions, the penumbra of any constitutional debate, require us to identify the vital rights and interests that need state protection and to think about how to protect them without impermissibly infringing either liberty or equality. Our analysis of the constitutional issues does not dictate specific answers to those questions, but it does, I think, constrain the options that we ought to consider. The future of marriage looks in one way a lot like its past. People will continue to unite, form families, have children, and sometimes split up. What the Constitution dictates, however, is that whatever the state decides to do in this area must be done on a basis of equality. Government cannot exclude any group of citizens from the civil benefits or the expressive dignities of marriage without a very strong and, I think, compelling public interest. The full inclusion of same-sex couples is in one sense a large change, just as official recognition of interracial marriage was a large change, and just as the full inclusion of women and African Americans as voters and citizens was a large change. On the other hand, these changes are best seen as a full realization of the promise contained in our constitutional guarantees. We should view this change in the same way. The politics of equal respect ask us to stop viewing same-sex marriage as a source of taint or defilement to traditional marriage, but instead to understand the human purposes of those who seek marriage and the similarity of what they seek to that which opposite-sex couples seek. When we think this way, the issue ought to look just like the miscegenation issue, as an exclusion we can no longer tolerate in a society pursuing equal respect and justice for all. Thanks.
Before we do questions, just an announcement. There's a reception in the foyer, or foyer, I guess, which is, up the stairs. That'll be immediately afterwards. And there's a lot of food there, so please don't.
Even more.
But we have about 15 minutes for questions, so yes.
Should I just yell?
Yeah.
Thanks. I think very persuasive argument. The only argument against that I found at all, so just from a devil's advocate point of view, at all attractive, was the freed argument.
Yeah.
That the state isn't really in the business of compelling people to do things that they find deeply offensive. Religious people is the case that Freed is talking about. And then you went on to argue that, well, we do that for kosher laws and we do that with respect to the Amish, etc. But remember that these are minorities within the democratic liberal state here. So suppose we're talking about, let's take the case of incest, sibling marriage. And suppose you're right to think that there are no good principled arguments against it. The health considerations turned out to be false, etc. But there, for both aesthetic and religious reasons, I think the vast majority of us would still find that somewhat difficult to swallow or deal with. Maybe that's something that will change, but at the moment it certainly seems to be the case. Don't you feel the pull of a Freed-like line to say, well, there the state in a democratic a situation shouldn't be just compelling people to allow this and support it.
Well, I think you're right, that it's the most persuasive argument, and not surprisingly, because I think Fried is a very thoughtful person, and it's actually a very good book, and his arguments against sodomy laws are quite persuasive and thoughtful, and so on. I think just a parenthesis, there's an interesting feature of the anti-sodomy law part of the book, which is that he says to endorse this conclusion that there should be liberty of sexual choice for all, we have to not think about the sex acts that same-sex couples perform. So I think there's some sort of disgustingness is still in the background of his thought. But anyway, you see, I think the issue is really the Establishment Clause issue. Most of the things that happen of this sort are, of course, impositions upon minorities of the majority preference, and they're not impositions. But so the situation in which Jews really did succeed in banning pork would just not happen. But that doesn't mean that when a majority does it, it's any better. And that's why I gave the example of cow slaughter in India. So here's a majority of 85%, and they've just succeeded in making it impossible for anyone to eat beef. Well, okay, now India actually doesn't have an anti-establishment commitment in its constitution. It has rather a system of plural establishment. So it's probably not unconstitutional under Indian law, but we've chosen the non-establishment route. And I think wherever you have the majority imposing its preference, even when it doesn't create a liberty problem, as it does, I think, here, you still have an Establishment Clause issue, and I don't think I see Fried really facing that. I would like to see how he would deal with that. I mean, the fact is that this is a preference that is backed by certain kinds of religious and secular views and opposed by others. So
set aside the religious stuff and think in terms of aesthetics, disgust, etc. And focus again on the incestuous case, where I think we do aesthetically, most of us still find it somewhat.
Where a fundamental right is not at issue, that's okay. But just remember that most states, until rather recently, had what are called ugly laws. People with disabilities were not allowed to appear in public. My colleague Adam Samaha writes about this and, rightly points out that he himself, he has a neurological disability, would not have been permitted, not only not to teach in law school, but to appear in public until about 30 years ago. And that was aesthetic, maybe, but, rooted in a kind of visceral disgust for people with disabilities. And I think the right thing to say about those laws is, if it's just harmless aesthetic taste, fine. But when it impinges on a fundamental right of individuals, no.
This seems to be, it ought to be a familiar observation, but I've not ever heard it before, which sort of surprises me. I wonder, one of the reasons that the sort of public debate about gay marriage is so contentious isn't that the popular understanding of the word marriage sort of muddies up a couple of categories, right? So it seems to me that from the point of view of the government or the state, the only actual meaning that marriage holds is the civil union meaning. And that seems to be a meaning that most people, even those who feel disgust, aren't that uncomfortable extending to same-sex couples. On the other hand, within various religious traditions, right, marriage has a much richer and thicker sort of meaning. And people are often, I think, thinking within or from within that category or that understanding of marriage when they do experience disgust. And so I've always thought that the proper solution to any problem that's perceived in this would be to say, look, we just don't even have state-sanctioned marriage at all. We simply have civil unions, right, from the legal point of view. And then various legal traditions have their own understandings of marriage, right? And then we would just sort of separate the two things out. That might be unrealistic, right, because perhaps politics and culture really can't be sort of disentangled so readily as that. It seems to me, I don't see why they couldn't be.
Yeah, I mean, that I didn't address this because it's about law, but I actually think something like that would be the solution that I would prefer. I'd actually rather go even further with people like Martha Feynman and Michael Warner and say we should just disaggregate all these different interests, sit down and think for a while, think what's the best way of protecting children, what's the best way of protecting dependent elderly people, and just sort all that out and start afresh. Well, we're never going to be in a situation of de novo rethinking, but we could at least move toward that. So that's what I would like. I don't see the disaggregation happening anytime soon, but I think the intermediate civil union position is is a possibility. However, what's crucial is it can't happen out of spite, as I said. Just as they couldn't close all the pools or they couldn't close all the public schools to avoid integration, then they can. So as long as spite is in the picture, there's a legal problem with doing that. And moreover, I fear that the civil union solution has a hard time getting going. I mean, one reason that I think we should rethink this knee-jerk opposition so many academics have to judicial activism is that legislative politics, there are even more problems in some cases. Like my own state in Illinois, there's civil union bill, which certainly if it ever came up for a vote, it would pass. However, it's not so much religious people, but it's the religious hierarchy. Politicians are terrified, and I've heard this on good authority from people involved in the legislature. They're terrified of being denounced when they run for re-election by the Catholic Church hierarchy. Now, vast majority of Catholics are happy with civil unions, but it's the hierarchy. And so, if the court did it, it would probably stand because the people support it. It's just that certain very powerful figures stand in the way. And so why should they stick their neck out? If they're doing fine, why they're coming up for re-election, why should they court this kind of very public and powerful opposition? So I think that the problem is that the civil union solution does run afoul of certain vested interests and therefore has a lot of difficulty anyway. But then right now, it also has this equality problem. And I think it's going to be very hard to get out of the idea that marriage has this dignitary and expressive quality. Moreover, I find that same-sex activists don't even agree with you and me. In fact, Liz Emmons, who talked about this we had an exchange at Columbia, she thinks that the problem is really for the non-religious people, because the religious people who want to get married go get married in their church or their temple. But what about the non-religious people who want to celebrate and affirm and do something splendid? They have no place to go. Well, I'm not so persuaded by that. I think that you can invent, people are very fertile and they can invent rituals. And furthermore, we know that anyone who wants to perform a marriage in Massachusetts can already perform a marriage. So long as you do it only once a year, you get a license for. So I think people are already innovating, and I think they would do it. But anyway, there is that argument.
Larry? To sort of follow up on this line of questioning, it strikes me that in Europe, where they take a slightly different approach to how one gets married, at least in some countries, that their practice might be of some value, even if it's not something that could be implemented because of our traditions. But it seems to me that we've allowed the state, by delegating the ability, the authority to marry someone to religious authorities, have unfortunately combined the official function and the private religious moral function. And if everybody has to go to City Hall to have an official ceremony performed, or else you're not recognized by the state as being married or having a civil union or whatever else you want to call it, everybody's got to go there. Nobody can have that done strictly in a church, but then everybody can leave the City Hall, as they do in Romania and France and places, and go to your church and have the ceremony, and it's perfectly accepted and it's celebrated. If we disaggregated the two, if we could, would that help at all?
I think it surely would, because it would remind people that this is a civil thing that's tied up with civil benefits, and the other thing is the celebration and so on. But that's not the direction we're moving in. Instead, we're moving to a more promiscuous kind of delegation. So let's say you sign up as a minister of the Universal Life Church on the internet. You can then perform marriages, but so it's just delegation to more people. And as I say, Massachusetts even allows any individual to do it, so long as they do it only once a year. So I don't see us going in that direction. People are attached by now to the idea that when it happens in the temple, that's the real thing. And it would feel to many people unsatisfactory and weird if it wasn't the real thing. Now, as I say, I don't agree with that. I wish we would do at least that and perhaps more, but it's certainly not in the cards anytime soon.
I wanted to return to incest for a minute, because your arguments are very commodious and appealing to me. that way because they leave radically open what a household would look like, what a marriage would look like, and all the many legal and social reasons for polygamy and for incest. And not just child care, but elder care. I mean, it's very reasonable that I should want to marry my mother and father, since I'm going to be entrusted with their care, and for tax reasons, inheritance, gift tax, all manner. And even if I'm having sex with them, it's not going to be procreative at this point. So the incest ban on medical terms wouldn't apply. I'm not asking this to be privileged because there are enormous numbers of I mean, healthcare is a big issue with elders and with spouses, and same-sex spouses not having access to it. But it's also the one really powerful argument against gay marriage that is made that you didn't address, which was the slippery slope argument, which leads to a certain moral panic reaction. That says, well, if gay marriage now, what next? Polygamy, incest.
Yeah, I mean, I have a problem with that argument and with what to do about it in this book, because this book is part of a series that my colleague Jeff Stone edits, which is for the general public, which is an attempt to, therefore persuade the general public on constitutional issues. And I've been torn about several questions where my own views are actually quite radical, but I feel like putting that up front might weaken the persuasive power of my arguments. And one is this area, and the other is the whole question of sex clubs, public sex, and so on. Well, on the second, I bit the bullet, and I have this whole chapter on sex clubs and public sex, which is pretty radical, I suppose, in terms of the general public. But on this, I just have been a little more evasive, although as time went on, I kept rewriting it and adding more of my own critique of the current prohibitions. Now, I think, for me, bestiality is in a completely separate category because it's an infliction of harm to animals without their consent. And I think there's just no way of claiming that an animal has consented to sexual intercourse. And in the absence of that clear evidence of consent, I mean, my view on rape more generally is, intercourse is not, there's rape unless there's positive affirmative evidence of consent. So that's, for me, the easy one, but for completely different reasons from the ones that most people seem to give. Polygamy and incest, polygamy I've actually written that I think, if you think what are the state interests, well, the sex equality one seems to me to be the only one that's very strong. But then suppose you have something like Liz Emmons has proposed, that is polyamory, that's sex equal, a kind of contractual sexual relationship among a group of people. I see no good reason against it. I mean, you could bring out administrative complexity, but then you'd have to see how far that would actually take you. Now, if, for example, then it depends what the argumentative context is. If some religious group, let's say the Mormons said, this is a religious commandment and we are going to pursue a free exercise claim, then at least under the Sherbert regime, the state would have to show a compelling state interest. What would that be? Well, I think administrative complexity has repeatedly failed to pass that test. It's not it may be a state interest, but I don't think it's a compelling state interest. So I actually think that at least if that was the argumentative context, polygamy would have to be permitted. So anyway, that's my view on that. I just sort of, you see how I dealt with it rather concessively, saying I think the arguments are weak, but at any rate, at present, we can see that states have these arguments. Incest, again, I think child abuse is a huge problem. And so given the huge size of that problem, a bright line rule on parent-child incest seems to me absolutely fine and defensible. But then when you get to the brothers and sisters, well, now we know so much about the genes, and we certainly don't forbid people with Tay-Sachs to get married. So I feel that it's just bad faith to forbid the brother and sister on these putative health grounds. If at one time states did think that they had that interest, they don't have that anymore. And as you say, there may be, I'd have to think more about this. If we could have a bright line rule that would somehow allow the elderly to marry their. But you see, then I think what we really need to handle your kind of case is this disaggregation. We have to think, what kinds of groupings do we want to give rights to in the area of tax, inheritance, immigration? And, what Warner does, pointing to the French experience, is to say, look, people who share a household, whether they're brother and sister, father and mother, or something, they should be able to get certain kinds of benefits that are appropriate to that status, and that doesn't have to involve having sex at all. And then maybe those who have sexual relations would get other, or would get other kinds of benefits, such as adoption rights. I mean, so we could sort it out. But to do that, we have to first think, and people are just unwilling to think. They would rather stick to the status quo rather than to think. Now, of course, in the thought process, we'd have to think about how the healthcare system would be structured. And best of all would be that all individuals would have satisfactory healthcare. Then we wouldn't have to engage in these games that you're talking about with the insurance companies. So I think that's the best solution there. But anyway, yeah. So I think it's very frustrating because the best solution, which is really to sit down and think, well, each of these benefits that's traditionally associated with marriage, to whom do we really want to extend this, given our current social knowledge and our current situation? And that process is just not happening.
Please join me in thanking Professor.
This has been a production of Cornell University.